The matter before the court is State of Maine versus Jeffrey Witham, and this is Hancock 23-421. We are being streamed live on the web, both by audio and visual. And if counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good afternoon, Rory McNamara for the appellant, Jeffrey Witham.
Toff Toffolon, State of Maine.
And counsel, if you're ready to proceed, Mr. McNamara, we're happy to hear your argument.
Thank you, Your Honor. May it please the court, counselor. The state's singular argument seems to be that defendant was not entitled to a pretrial hearing. Yet the U.S. Constitution and Maine statute both independently require such a hearing. The error is as plain as errors come. Respectfully, it was equally plain nearly 2 years ago when defendant demanded a hearing. To now give any remedy short of a new trial and the return of money would be to encourage sandbagging. A defendant's chances of prevailing are hurt by delay of this kind, and this court should not incentivize the state arguing against hearings that obviously must occur. Memories fade, pay stubs and receipts disappear, particularly when you're incarcerated. The state has not once asked for a hearing required by law. It's simply too late to do so now. I'll add that the principle of party presentation probably precludes it as well. If there's any time remaining, I'd cede it back to the court. Welcome questions.
So doesn't the request for a hearing, however, belong in the case in which the money was seized?
So it was made in that case.
And
in
it could be reviewed in that case.
And, well, it was
at some point
made in several cases. So made in that case and in these two docket cases. Yeah. So if Your Honor were to look at page, I believe it's 112.
I understand it was docketed that it was made in more than one case, but
Correct.
Doesn't it belong solely in the case in which the money was seized?
No, it doesn't. It also belongs in a case in which it's necessary to hire counsel, which is this case right here. In this case, the defendant claimed that I need that money in order to pay for counsel of my choice.
What if it had been seized in a case from another state or by the federal government?
Well, I think that muddies the waters a little bit as to the logistics of how it ought to happen.
Would you still be entitled to a hearing in this case?
Absolutely.
Could a judge order that money returned?
Could a judge in another jurisdiction?
Assume it was taken, like I say, whether in another state, by the federal government, whatever.
I think, yes, absolutely, could issue an order that says, look, this money is necessary in this state, in this jurisdiction, or the federal government, to pay for counsel. It needs to be returned. And then the receiving state, if you will, receiving jurisdiction, it's up to them to decide whether or not they want to honor that, if they want to have strong, fundamentally sound convictions or not. And certainly the conviction in this case has been obtained without the necessary hearing that's both required by statute and by the Constitution, and quite clearly at that. And I think now, 2 years on, I think it's going to be to my client's disadvantage to go back after being incarcerated that whole time, to go ahead and position everything as if nothing has happened.
Was there a hearing of any kind, whether evidentiary or not? Was there a hearing of any kind held in the drug case?
No, to my understanding, there has not been, and certainly now, this is a difficult question, another one to answer about jurisdiction, whether or not, given this appeal here, there is jurisdiction to decide, now that this appeal is pending here, on the remaining drug case, whether anything there could be decided regarding this issue while this appeal still pends in the trial court.
But how can we make a decision in this case with respect to the money in the drug case that was allegedly subject to forfeiture, to the extent that matter is not currently before us?
Well, Your Honor, that matter is not the only docket number that has been docketed under the motions for the hearing. The request for the hearing on page A12 of the appendix was under those, I believe it's 3 separate, 2 in this case, docket numbers, and the docket numbers in the drugs case. So what needs to happen is a hearing consolidated to all 3 of those matters, which could happen on remand. It is defendant's argument today that a hearing such as that is something the state has not asked for at any point. And party presentation would certainly dock a defendant or his counsel for not asking for that. And at this point, the state hasn't asked for that hearing. It's time to return the money. The statute requires a prompt post-seizure hearing. That certainly has not happened.
Did he request the consolidation below?
He, in so much as he put 3 docket
The docket numbers on the motion.
on the motion, yes. So I think that that's certainly for a pro se defendant, that's a pretty savvy thing to do.
Well, the
if you
court
want our
also
case to stay.
recited all 4 dockets and held the hearing that seemed to relate to all those
Right.
dockets.
And 2 of the attorneys for the state, both in the drugs case, and it wasn't Attorney Toffolon, it was his predecessor on this underlying 2 cases, was there as well. Yes, so there was a hearing. It was not an evidentiary hearing. At that hearing, appointed counsel asked for the opportunity to present witnesses and evidence on this issue. So I do think it was adequately preserved.
Well, he
in
asked
that
for a
regard.
continuance. He didn't, to present witnesses at a later time,
I
right?
think it was unclear whether, certainly at that point when you're there, ready for a hearing, when there's been no discussion about whether or not witnesses could have come forward at that date, I think he was saying we need a continuance in order for me to present those witnesses, but yes, we would like to present them. It was almost like a pre-hearing, if you will, to decide whether or not the defendant was entitled to an evidentiary hearing.
Well,
the
and it
defendant
wasn't denied on the basis of, no, you don't deserve a continuance. It was basically, I'm not going to give you an evidentiary hearing.
I think that's fair to say. Certainly, I don't think he was going to give a continuance based on his reasoning either, the judge, that is.
Under Section 5826, the trial against the property says may be by jury and must be held in a single proceeding together with the trial of the related criminal violation. Before having a hearing then to return the property, does the defendant have to execute a waiver of the right to jury on it?
No, because I think the trial will naturally come later. You won't have an entry of a forfeiture. You won't have a criminal conviction, if
Well,
you
is it
will, for the
returning the
forfeiture.
property essentially denying the forfeiture?
Returning the property to the defendant, certainly, but that is not a right. I think that if you have exercised your right to a hearing, you've demanded your right to a hearing, you're probably going through the steps of waiving any, it's not even a negative result that would accrue to you if you were to win that hearing. I think you naturally want that money back there, and that's what you're signaling when you are saying, I want this hearing now. Now, I understand it does get a little bit more muddy were you to lose, were the defendant to lose that hearing, but I think still thereafter there's the opportunity to prevail in front of the jury.
Well, the statute
that.
sets forth a 2-step process for seized property, the initial restraint and then the forfeiture. And the initial restraint is based on probable cause. So what was he requesting the court to hold a trial on the forfeiture, or was he simply asking for reconsideration of the order seizing the funds?
On the forfeiture, he was offering evidence that would have shown that this is money. I don't have the motion in front of me, but there's language in there, if I recall correctly, that says something along the lines of, I was saving up this money, I was earning this money to pay for counsel. This was right to the question of forfeiture, not to the question of probable cause writ large that the court
So
said
it was not a collateral attack on the grand jury indictment, in other words, you're saying?
Correct. And the Supreme Court in Cayley made the distinction quite clearly between the 2 types of hearings, and the former, the one that just attacks probable cause as a collateral attack, you might say, is not required under the Constitution. We're not arguing for that today. We're not asking for that. We're simply arguing for the opportunity to put forward evidence as to traceability, as to the forfeiture, as to whether or not those assets are something that are properly before the court to be seized.
What you want is for the state to try their case.
Well, no, that's the distinction, and the court made that in Cayley. If you're asking only for the former, for what Cayley said you don't get to attack probable cause as to the indictment itself. That would be previewing the case in a way that might be unfair to the government, at least in the constitutional analysis.
Oh, no,
that
essentially you're
occurred.
conceding probable cause is what I understand, but he's still, in order for the defendant to, wants an opportunity to prove that the proceeds are really fairly gotten, the state also will have the opportunity to prove that they were in fact ill-gotten, which
Right.
means the state has to try their case. And again, I'm struggling with the right of a jury in that.
Well, I also am concerned about the interest of a defendant in saving until trial his discovery and his strategy.
So wouldn't the proper procedure in this circumstance then, after the proceeding on, I think it was January 18th of 2023, you get the decision from the court saying, well, there was a determination made in the underlying drug case, and to the extent that the money was taken, everything seems to be appropriate there. Wouldn't the appropriate step based on that determination would have been to make an interlocutory appeal?
No, I don't think so, because the issue was still, we wouldn't be here if my client was acquitted at trial, or if my client had prevailed at trial or on a different motion. We wouldn't be here. So the whole point of an interlocutory appeal, I think, in those circumstances is, well, defeated.
Well, except your point was, by not having the money in the first place,
Right.
it's not valid.
But
So-
that's the fire that the state plays with when it's both required by statute and the Constitution. You have a constitutional right, and all along, including in the red brief, they have denied the right to a hearing. So I struggle to see how it suddenly
Isn't that
became...
all the more reason to file the interlocutory appeal to get it before this court, to the extent that your client's being deprived, he says, of the opportunity to hire the counsel of his choice by virtue of this determination that's been made with respect to the forfeiture or the restraint of the proceeds?
I'm aware of no precedent that says it's appropriate in these circumstances to file an interlocutory appeal. And in fact, the
Mr.
request...
McNamara, I've never known you to be hesitant to break new ground.
I was not handling the case at the time, of course, but also defendant had to perfect his request for a new trial, and he did that after trial. He couldn't have done that before trial.
Can I ask you a question that's really kind of off the mark, but I'll ask it anyway? I take it the the drug case has not gone to a verdict.
That's correct, yes.
So let's say it did, after the fact, he was found guilty of that, and it was found that, yes, these proceeds are subject to forfeiture because they were part and parcel of that. Is it possible that that result could retroactively moot what happened down below?
Not in this case.
Because?
Because 2 years have passed, and 2 years is an awful long time for a man incarcerated to be able to go back and place into context where that money came from exactly. And that's what we're dealing with, such significant harm. Thank you.
Thank you. Counsel?
The state contends that 1526-4 is dispositive of this issue. It says, trial against property charged by indictment, that is the drug money, maybe by jury, but must be held in a single proceeding together with the trial of the related criminal violation. There's no opportunity to give the money back before he has his trial in the drug case. I'd like to use the rest of my uninterrupted time to address a few things that Brother McNamara raised in his reply brief, and the first touches on the identification of multiple defense attorneys in refutation of the state's argument that Mr. Fenstermaker, the preferred attorney, could not be utilized. I respectfully remind the court that no other attorney, potential defense attorney, was identified, and the state asserts that the defendant would have to show some actual prejudice in any regard. Now, he didn't apply to MCLIS or the court to change his attorney to another court-appointed attorney. He didn't indicate that his trial attorney was incompetent. He hasn't filed a PCR. So does the defendant have some burden to show actual prejudice from the court's refusal to give him a hearing on the release of his funds so that he can hire a lawyer? And I do want to comment on Brother McNamara's reply brief analysis of the mental exam requirement. Again, how does he show prejudice? He denied the court's inquiry about whether he wanted to have a mental exam before the trial. He presumably had the defects that he complains of now in his brief before his trial, and so he can show no prejudice. Further, he could have petitioned MCLIS for funds to hire a private forensic examiner had he been aggrieved by Justice Larson's decision to deny the request.
I see that the green light is on. Can I go to one of the issues that we didn't talk about with Mr. McNamara, but with regard to the sentencing and the use of a failure to accept responsibility as an aggravating factor versus the use of an acceptance of responsibility as a mitigating factor? Is it time to have a bright line saying a failure to accept responsibility can never be an aggravating factor? In other words, we're really setting up a dichotomy where it's either a mitigating or an aggravating, but that's a false dichotomy, isn't it?
That's a policy decision that doesn't apply retrospectively to Witham, Judge. Also, I'd say that
what does apply is we've said you cannot punish somebody for exercising the right to have a trial. And by failing to accept responsibility, isn't the judge, I mean, I've read it and I've read it, and the judge really pretty much seems to be saying, you had a right to have a trial, but when you had a trial and you were found not to be credible and found guilty, that's not an acceptance and that's an aggravating factor. How is that different from punishing somebody for exercising the right to have a trial?
you already decided that in Grindle, didn't you?
Well, I don't know that we have, and we've been wrestling with it. It keeps coming up. We are wrestling with it.
And I respect your decision to change the course of future proceedings, but Grindle is the law now. Grindle applied at the time that Witham was sentenced.
We have never said that it's okay to punish somebody for exercising the right to have a trial, to simply say that by having a trial and having been convicted, that is enough to say that that's an aggravating factor for a failure to accept responsibility. We've never said that.
Grindle's language was pretty clear, Judge, and I would respectfully ask you, as you've said, you've read and reread it, A88 sets forth clearly Justice Larson's comments. If you extract what the reply brief quoted, you've got a problem, perhaps. But if you read all of A88 and you see Justice Larson's...
I have it open.
Yep. So...
So he did here exercise his right to allocution, but he said something sort of went sideways. And I apologize. I apologize that I went to trial here because those guys made me go to trial because they make an agreement that I accepted. Does that overlap into that failure to take responsibility, that sort of blaming other people for the fact that a trial had to be held?
Well, now he blames the state because it's not part of the record, so I'm hesitant to bring it forth, but a plea agreement on much more favorable terms that he ended up with was extended and rejected by Mr. Witham. So instead of focusing on the matter at hand, that is discussing with the sentencing court the ramifications of the trial outcome and his reaction to it, he veered off and said, in essence, man, I wish I'd accepted that plea bargain.
But what I'm asking you is, if he didn't make an allocution, we wouldn't be talking about this here today. But the court seemed to really key in on the fact that he apologized for something that you did, which is not to come to an agreement, putting the blame there as opposed to taking any responsibility for anything else. Did that factor into the judge's, well, the judges cited it specifically in pronouncing sentence?
And that's appropriate. If you're
well, an allocution is a partial waiver of their right not to testify. So if they allocute, then why can't the judge say, I've listened and I'm not hearing any remorse in what you're saying. You have a right not to say anything, but here you're saying things and then not hearing remorse.
And as Justice Glassman pointed out, Justice Connors, that's perfectly appropriate for the sentencing judge to consider.
But let me get back to the first issue, the funds, because I want to understand what your position is. So there's a motion in all the dockets that says, I want to have these funds back so I can hire the counsel of my choice. And there's a non-evidentiary hearing in which the lawyer cites the statute and also cites the Constitution and says, I want a hearing, evidentiary, that will show that these funds were not related. And the result of that is he doesn't get an evidentiary hearing. So you're saying that's okay because?
Of 1526.
Because the statute requires you to do what?
The statute requires the court to hold a hearing on the issue of forfeiture must occur at the time of the trial on the
So
merits
you're
of the
saying
charge.
he doesn't have a constitutional right to an evidentiary hearing on this before the trial? That's your position?
I'm saying the court needs to give weight to 1526 unless you want to tell us it's unconstitutional.
Well, we have a statute, but we have a constitution. And the Constitution trumps statutes. So are you saying there is no, and he cited the Constitution. So are you saying there is no constitutional right greater than what's provided in the statute, and you're reading the statute as not requiring an evidentiary hearing?
I'm no constitutional scholar, but my direct response to your question is, if that were the case, Judge, how would MCLIS even function? You're not guaranteed the lawyer of your choice when you have a court-appointed lawyer. You're guaranteed a competent lawyer. So the trial courts would routinely be confronted with a request that I want Walt McKee to try my case on an appointed basis because I've got a constitutional
that's
right
not
to have a
the
lawyer of my
argument.
choice.
No, that's not the argument. The argument is not that you get the lawyer of your choice on an appointed basis. The argument is I have the right to hire an attorney of my choice if I have the funds to do so, and he's claiming he did have the funds to do so, and the state was wrongfully withholding those funds. Those are different arguments.
Well, again, I can't claim to be a constitutional scholar. All I can say is the state and the courts below you operated according to the statute and did justice according to what the law was at the time. And if
Well,
you prospectively change it, you change it.
He would have had a hearing at the unified hearing, right? The motion he's pursuing would have occurred. He wasn't denied the right to have a hearing. It just had to be unified with the other matters.
Well, what other matters are you referring to, Justice Meade? The other matter that I'm referring to is the trial on the merits of the
That's what I'm
drug
referring
case.
to. That's what I'm saying.
Oh, okay.
He would have that right down the road. So if there's a constitutional issue raised here, it's whether he had some constitutional right to have an independent hearing in contravention of statute before he would have had his hearing at the trial.
Correct.
And isn't there some federal law that says he is entitled to that?
I don't know.
I asked Mr. McNamara that if this trial, the drug trial takes place and the forfeiture takes place and he's found guilty and the forfeiture is ordered because it's connected up with a drug offense, I said, would that retroactively moot what happened down there? And he said 2 years is too long. Did you have a position on that?
I think that's a horror show that we'll try to reserve for another appeal, perhaps. But my attitude is 2 years isn't too long. If he filed the motion, he had the requisite pay stubs and other things that Brother McNamara referred to on hand, presumably. He wanted to present witnesses and he wanted to present this paperwork, apparently. There's no evidence that those items still don't exist.
But he wouldn't have gotten a hearing under your analysis because it had to wait until the trial for that unified hearing.
Correct, and I'm saying the passage of time, which was what I thought you asked me a question or two ago, isn't material. Because he still has the resources for the hearing. But I can't see how the state can be deprived of saying, we can prove that $27,000 was the fruit of drug trafficking. We've got to do it at a trial. We don't want to have a trial within a trial, which the last set of attorneys who appeared before you discussed. We don't want to have a trial in front of in a trial here. We want to have one unified trial. That's why we have 1526.
Well, you don't want to do a dress rehearsal of the evidence of your case in one proceeding and then go into the same evidence at the actual trial for the drug offense.
Why not just have a trial? Why not just when he makes the request to have it returned, if there's a right to have a trial, it's like, fine, that triggers, you're on the next docket call for this drug case.
And I think that's wonderful, and I'll use 10 seconds of time, if you'll allow me, to compliment the court on finally assigning a full-time local judge to Hancock County so that we now have 9 months of trial time. But this all didn't occur during COVID, and then we didn't have a local judge.
But isn't the problem here that Kaylee, the government even even conceded that you get an evidentiary hearing pre-trial. And then the lower courts of appeal have said, yes, you do. And don't we need to confront that when we're making this decision on appeal now? And how can they show prejudice in something, isn't this a structural problem because you can never show how you'd be prejudiced or not prejudiced by not getting your right to a counsel of choice?
Well, I don't know that having the right to your counsel of choice is a right guaranteed by the Constitution. You're guaranteed competent representation, free if you can't afford it. And again, I get back to the issue of he needs to show some prejudice. He can't.
It's in our Constitution. The Maine Constitution says you get a counsel of your choice.
If the counsel of your choice will agree to represent you.
You can afford it. You have to be able to pay for it, and then there are some limits, but there is a constitutional right to your counsel of choice, isn't there?
Well, if there's a constitutional right, and I know what your response will be, you didn't get his hearing so he couldn't show it, but wouldn't he have appended to his motion a letter of engagement from the lawyer saying, if you get your 27 grand back, I'll represent you. But what he really wanted was Mr. Fenstermaker. Please remember, he identified no other lawyer. That was just a throwaway line. He wanted Mr. Fenstermaker. Mr. Fenstermaker was not available.
It seems to me we should be, and I think the appellant is asking us to view his motion to the court, which was made in multiple docket numbers, as in effect a motion for speedy trial on the drug charges, and in effect, or a motion to sever the forfeiture counts from the other charges in that case and have a trial, speedy trial on the forfeiture charges. Because you're right that the state can't be deprived of its right to prove, if it can, that the funds being held were associated with an illegal drug transaction. So could the court in this case have continued the case that's on appeal and scheduled a trial on the forfeiture charges, or perhaps all of the charges in the other case?
Justice Horton, I think that's a great idea. As I just said, we have Justice Stewart up there. He's hammering out trials right and left. Issue an order that says this case has got to have priority. We'll let Brother Horn try it, and if he wins, we're going to keep the money, and this will be moot.
Did the court abuse its discretion by declining to do that?
No, but even if it did, you've hit upon a perfect remedy.
Thank you,
But,
counsel.
sorry, is opposing counsel correct, though, that that's a structural error?
I'm sorry,
Is opposing
Judge.
counsel correct that the failure to hold that evidentiary hearing is a structural error?
I don't know.
Thank you. 548 U.S. 140, Gonzalez-Lopez says it is structural error. It's structural error to deny the opportunity to hire counsel of one's choice. So that's not a point that's open for debate here. I also want to push back on the notion that somehow a hearing is the same thing as a trial. Hearings happen all the time. Pre-trial hearings happen all the time. And that's what we were talking about here. And that is what is required by the statute, in addition to the Constitution, under 5828(1)A. I'll read it. Following the seizure of property, a defendant or any person with an interest in the property has a right to a prompt post-seizure hearing. Very plain language. Of course, any interest in property implies, quite plainly, that there's an opportunity to litigate what interest in that property you have. And the Supreme Court's case law, certainly the Cayley decision, the Luis decision, made it very clear that there is no...
Well, the problem is that that statute says you have a right, and the Supreme Court, you have a right to a hearing, but then whatever it is, 5826 says...
Trial.
Trial. But as I proposed, then it could be...
Right.
Parties could waive the right, I think, to have it done in one trial, but...
As in the context of a suppression hearing before trial, when you go through and you litigate what was the seizure of property, perhaps attended to a probable cause or a search warrant, was that legal? Was that lawful? That property would be returned at that time. And that's what, this is very similar to what we're asking for in this context, which is a pre-trial hearing at which you get your money back if you can prove what needs to be proved according to the statute.
What about the impossible, in effect, the state is presenting an impossibility defense based upon the suspended status of the attorney that
Yes.
Mr. Witham indicated he wanted to hire.
Thank you. I appreciate that question. I will go outside the record because counsel went outside the record. I have seen from another lawyer the certificate that says, I'd like to be, pay me $25,000 and I'll be your lawyer. So that was there, and that was represented on the record that there are other lawyers to be had here. So that's not something. Also, I push back against the notion that the state is due the opportunity to defend against the possibility that this money is not traceable here. The state has agency through its attorneys, and those attorneys have not argued until the very last second of oral argument that there should be any opportunity to do so. All the time in criminal cases, we see defense attorneys waiving, abandoning, forfeiting proper standards of review, arguments, entire remedies, losing trials, and those consequences have effect on defendants. And I think it's important that those arguments that are made by counsel for the state have very similar effect here. In this case, that's what's due. Thank you.
Thank you. All right. Well, thank you, counsel, for this interesting argument. As is our usual practice, we will be taking the matter under advisement and issue a decision in due course. And with that, we'll be in recess on this matter.